All right, it's 9 o'clock. So to be fair to everyone who is on time this morning, we are going to get started. So welcome back to the second day of our exempt conference. I hope everyone got some great value out of the first three sessions. And as a reminder, recordings and slide decks will be available sometime late today or tomorrow. So just keep out for those. So we are happy to welcome Amanda Lau to the Lumsden and McCormick Conference talking about workplace investigation. She is a partner at Phillips Lytle. Before I go into the formal introductions, I do want to go through some housekeeping, and bear with me for those who were on yesterday. We have some new people on today, and I just want to make sure that everyone hears them. So I just mentioned everything will be recorded along with the slide decks. Everything will be available on our website, and we'll share links to that by the end of the week. Chat and Q&A are open. If you have a comment or a question for me, if you could put it in the chat, and any questions for Amanda can go in the question box, and we're going to take questions throughout. So I will interrupt the interrupt the presentation when a question comes in. Of course, we're offering CPE. It's 1 hour of CPE for this. So there are 4 polling questions. You need to answer all 4, please, and then complete the survey at the end of the session. A certificate will be mailed to you for each individual webinar you attend through the entire conference. So if you attend all 6, you'll get 6 separate emails. There is an evaluation at the end, on those emails. If you could please complete that survey if you want. It's optional, but we do appreciate any feedback you can offer all of us. So I think we're done with the housekeeping. I'm trying to make that quick. And so we're going to move on to the formal introduction of Amanda. Like I said, Amanda Lau, she is a partner with Phillips Lytle. She concentrates her practice in civil litigation matters before federal and state courts, administrative tribunals, and appellate courts. She's a member of the labor and employment practice teams at Phillips Lytle, and she represents both public and private sector employees regarding employment issues such as discrimination, harassment, employee disloyalty, and embezzlement, just to name a few. I will put her full bio in the chat so you can link that. It's also on our website. So I'm going to welcome Amanda and turn the program over to her.
Thank you, Maria. Thanks for everyone for joining and having me here today. We're going to be talking about internal investigations. I'm going to share my screen right now, start our PowerPoint. Okay, all right. So today's session is going to focus mainly on investigating complaints or allegations that involve EEO, so equal employment opportunity categories. So based on race, gender, or any other type of protected category. We're not necessarily going to focus on internal investigations for whistleblower, OSHA, or things of that nature. I can talk to you all about that at a different session, so many different topics to talk about. So we're going to focus mainly on EEO. And what I'd like to talk about today is essentially general principles, what you should be looking for when you're creating your policy, how you want to investigate. You have a lot of discretion when it comes to how you want to investigate and who's doing the investigation process. I want to talk about specific examples, and there's 2 examples included in these materials, real life examples of matters that I've investigated or been brought on to investigate. And then I also want to address some topics and trends that I'm seeing from many of my clients about what they're seeing or what they're having questions about. And maybe some of you here have the same questions as well. As Maria said, please feel free to put in some questions in the chat. If we were in person, this would be more of a back and forth, but I would like to hear your questions as soon as it pops in your mind. I'd be happy to answer those. Okay, so in general, investigations, whether you're conducting it yourself or you hire an outside investigator like myself or someone else, we go through a process, right? We have a policy, we have procedures that we like to follow, and we like to follow the best practices. And one of those best practices is anytime someone comes in with a complaint, an EEO type of complaint, we're going to need to update those key stakeholders that are in the quote unquote need to know category. All right. So if you are the director of human resources, you are more likely to be in the know. If your organization doesn't have a separate HR department, you may be the CFO who's also acting as a human resource person. You would be in the need to know. You might have a vice president or a president who needs to be looped in on these conversations, or in-house counsel. But I like to keep my quote unquote need to know category quite small. It's because we want to try to ensure confidentiality to the extent that we can, which we know is impossible, but we want to really keep our world small. And it also will help in terms of identifying witnesses and other things that we're going to be talking about. Now, you might have people in your organization who want to be in the know, but don't necessarily need to be included. And that happens because these investigations, we have really great stories, right? Crazy stories, things that you would never think of people would be doing at work, they're doing at work, right? Example I had given in a previous presentation was, I got a call from a client saying, hey, we're getting some complaints that people are showing up to work naked and high, right? We're all professionals here thinking no one in their right mind would be doing that, right? But then again, naked and high, why be one without the other, right? And so, so these stories are absolutely crazy for sometimes, and they're really fun conversations, but you don't need to be having them, right? Keep your world of people who are in the quote unquote need to know, keep it small, keep it to those who are essential and not just want to hear the fun gossipy stories, okay? When you're creating these EEO investigative policies, you need to determine who is going to be your investigator or investigators, and if you're going to have a separate decision maker, who he, she, they would be. Okay. So you may be a large organization and you have multiple people who are trained to be investigators. You may be a small organization and you only have one person available. You may be a smaller or large organization, you have no one available, and that's when you need to look elsewhere and hire an external investigator. When you're creating your policy, you need to decide, is that investigator also going to be making recommendations about whether someone should be terminated, whether they should be suspended, or are you going to have that investigator just create the world of facts, present it to a separate decision maker, and that decision maker will then look at everything and decide what he, she, they, or the panel want to do with that investigation. When you're starting these investigations, taking in the complaint, and that's probably all the information that you have at that point, you're going to need to determine, are interim measures necessary? So an interim measure could be, do I need to suspend someone with pay pending the investigation? Do I need to remove a supervisor-supervisee relationship, at least on a temporary basis? Those are the people involved. Do I need to, move some shifts around, or move people physically, like separate offices, to essentially protect the status quo and protect the complainant during the pendency and investigation? I realize that's not always possible, but I do try to, I will err on the side of caution in terms of protecting the alleged victim at that point in time when I receive a complaint, if I think that interim measures are needed. Again, not always possible. There was a matter that I investigated for a municipality where there was an individual who claimed everyone in the department was harassing her. There's CBAs involved. There's workflow that was involved. We were unable to move everyone else out of that department, or else that department didn't function. But in that case, we recognize there can be some risk, right? You're supposed to be protecting the alleged victim, and you should be taking steps to the extent that you can to maintain that status quo. So now that we have been talking about our investigators and whether we want to have one investigator and one decision maker, whether we need to implement any interim measures, let's talk about planning your investigation. Like I said at the beginning, you have a lot of discretion about how you want to investigate, right? So if you get in a complaint that someone of gender discrimination, okay, you can decide the order of the witnesses that you want to take. You have that discretion. You can decide, are you going to have the witnesses prepare their own statements and submit them to you? Are you going to interview them and take notes yourself? and then provide them with the statement to sign. Or you can provide statements at all. Are you going to ask for there to be a recording? And we'll talk about that in a little bit. There's a lot of discretion about how you want to conduct this. When you're planning your investigation, you need to be prepared that, at least in my world, the complainant, the respondent or subject or third parties may ask, can I have an advisor present with me? Can I bring my attorney? You need to be prepared for those types of questions. If you are an organization that has a CBA, you probably have the person probably has the right to bring their union representative with them. If you do not have that, are you going to allow them to bring an advisor or a witness into your interview meeting in general? Attorneys, I get a lot of, as an attorney, I receive that question a lot. Do I need an attorney? Can I bring my attorney with me? I tend to err on the side of caution and say, yes, of course you can bring your attorney with you. Now, again, some people will say they have an attorney and they don't, and that's a frequent occurrence. But if someone feels that they want to bring their attorney with them, that does not bother me at all to have them there, especially when I'm doing the interviews. And we can talk about how to handle advisors and attorneys who participate in an investigation in just a minute. And when you're planning your investigation, what I really want you guys to focus on is speaking with the witnesses, determining who has firsthand information and knowledge and order of the events. You're going to have a lot of people that come to you with hearsay, so-and-so told me this, so-and-so told me that, and you're running down the line to figure out who actually saw or heard the bad thing, because the firsthand information is crucial for when you're actually determining what exactly happened for these complaints. All right, so additional items to consider when you're contacting, when you've been contacted about a complaint, looping in human resources, looping in legal, determining how are you going to address it. So, for example, when I'm planning my investigation, I look at my org chart. Okay, who does the complainant report to? Who does the respondent report to? Should their supervisors be the investigator in the case? Probably not, right? Probably looks biased, probably has an appearance of bias, whether or not that person is actually, would actually be biased in the case. So review that organization chart and see, can we handle this ourselves? Can this individual handle the case without a conflict or appearance of bias? Especially when you start getting into the higher levels, right? You're getting into your senior admin, you're getting into the vice president of the company, you're getting into the president of the company. Who is going to be doing the investigation of that individual, right? I do not encourage a subordinate, to be doing an investigation of a higher up, even if that person is just, spot on, impeccable investigator, would not ever feel that they were biased or would not feel pressure to come to a conclusion. It just tends to look bad, right? And so when you're contacting human resources or legal for those higher ups, maybe you need to bring in an external resource to do the investigation. Confidentiality, again, like I said at the beginning, we can't guarantee it, but we strive for it, right? So when we're doing these investigations, I advise people, we try to keep this as confidential as we can. We cannot guarantee it. And the reason being, if a complainant brings forth a complaint about a respondent or respondents, that those individuals have the right to know what's being said about them, right? How do you defend yourself if you have no idea what's being said? Okay, I think it's akin to being called into the principal's office and saying, tell me what you've done. And they say, well, I have no idea. Tell me what I'm accused of. No, you tell me everything you've done wrong, right? That's not fair. So I will inform a complainant that the respondents will be advised what is being said. And so they have the opportunity to present their side of the story. Okay, so that's confidentiality. Advisors or attorneys who are present again. This is going to depend a little bit on if you have a CBA or if you have a policy that provides your employees with certain rights with attorneys or advisors. But I really, at the beginning of an interview session where an advisor or an attorney is present, I set the boundaries, right? They are there to support, they are there to supplement, they are there to witness what is occurring. They are not there to steer or deter or interfere with your investigation. And I make that very clear when I have someone participate. Now, you may have a witness walk into your office and say, should I have an attorney? I do not like when anyone provides legal advice on that topic. I don't like when they say, oh, sure, you can go get, you should get an attorney, or no, you don't need one in this process. I defer it back to them. Like, well, if you would like the opportunity to go speak with someone, I'd be happy to give you that opportunity to do that, and then put them on a tight time frame. Okay, but I'd like to see you back here in 2 days if you've secured someone to come with you, right? Just keep it on a tight time frame, because we want to do a good and efficient investigation to keep things moving along. Okay, uncooperative witnesses. This is something that's going to happen, right? And as employers, you think we can compel our employees to participate. And I would like to think that as well, but everyone has their own reasons for being uncooperative. If it is a respondent, someone who's being accused of something bad, and they do not want to meet with you, they do not want to participate, whether they've actually done the bad thing or not, I will try to talk with them and ask them to cooperate, because I want to hear their perspective. That's the point of the investigation. I want to hear your side of the story. I want to hear what you have to say in response, or if you have any witnesses or documents or something that supports your version of events. If you choose, I'm speaking to the respondent, if you choose not to speak with me or provide that perspective, I'm going to continue my investigation. I'm just going to continue it without your side of the story. And usually that will get them to come around and participate. Same thing with non-party witnesses. So someone who's not the complainant, someone who's not the respondent, but they're just a regular old employee, and they just don't want anybody to get in trouble. They don't want anything to do with any of these things. And I understand that perspective. But again, I try to talk with them and be like, I understand you don't want to, but this is a very important issue. As the employer, we have an obligation to investigate. I'm trying to get to the bottom of this. I'm trying to figure out what exactly happens. And I would really appreciate that you participate in this investigation. Now, I've had some people ask me, well, can't I just compel them? They're my employee. I can make them come. Sure. And just think about what kind of response you're going to get, right? If you're compelling someone to come to your office and they just refuse to participate, that is a protected activity, right? They are choosing to make certain statements or non-statements in your investigation. So I think we have to be very cautious about compelling someone against their will to participate in an internal investigation. I always try to have a nicer conversation to get them on board with what we're doing. Another consideration, conflicts of interest or appearance of bias. Again, that's when you have the subordinate investigating a supervisor. I never like how that looks. I like to get someone else on board. Even if I've done the best organization policy and I'm looking at the org chart and I'm looking at, okay, if this person's accused of someone, here's my investigator. If this person's accused, here's my investigator. And I have that prepared and it's been sitting on the shelf for 5 years, and that's great. And then something actually comes about, I take that policy down, and you need to look at it and really update it. Is there anything else that could even be an appearance of bias? Did something happen in the interim? Are people understood to be very close friends, even though that they're in 2 different departments? You might want to consider that when you're deciding who should be the investigator, again, the decision maker. And I have on here a appellate panel. I have some clients. Obviously, higher ed is its own world. They've been using appellate panels for a while, but some people will have either decision makers, or they'll have the ability to appeal a particular discipline, and they'll have a panel of 1 to 3 individuals. All right, even more things to think about, right? Because there wasn't enough yet. Due process, essentially the fairness of an investigation and how you're going to go about it. You're going to consider your weight of your evidence, right? Most of you are looking at a more likely than not standard. So if 50% of the with a feather, did something happen? Is it more likely or not that it happened? That's what you're considering for the most part when you're doing these investigations. Dealing with technology, boy, that can be fun, right? Or could documents or emails have been altered? That may come up during your investigation, or accessing or deleting evidence, right? If someone said, oh, there was these messages sent, I don't have access to the email anymore, but you as the employer, you have them on your server, you have the ability to get those documents. Do you need to take that step? I'm going to give a couple examples coming up. Discovery of additional policy violations. This happens frequently, right? So if we're doing an EEO investigation, but we find out that, oh, this witness or this complainant or this respondent may have also violated our code of conduct, or something else, one of our other policies while we're doing the investigation. How are we going to handle that? That is definitely an investigation consideration. Determining appropriate discipline. Who's going to be imposing that, right? If you have an investigator, does the investigator then report up to director of HR? And director of HR determines the appropriate discipline. And that's my favorite phrase right here, is up to and including termination. We use that all the time, right? Gives us a lot of room. It could be suspension, it could be a written warning, it could be a verbal warning, or you can be fired for it. So that covers the whole line of potential sanctions. Insurance carriers. The reason I have that here as as an investigation consideration is there are some insurance carriers who will have or insurance policies that will have riders on them that will cover an outside investigator. And then inquiries from other employers. So for the most part, most of my clients, and I'm sure many of you on here will, if you get a call from a former, an employer who is looking to hire one of your former employees, what you will do is you will validate the dates of employment and the title, right? That's basically it. But there's other times where that could be considered, or you may receive a claim of retaliation, depending on what is disclosed, which is why we do not disclose our internal investigations externally. All right, starting with our first polling question. So this is my first time doing this. So
I'm going to interrupt just a quick second.
Sure.
So this question is two parts, as obviously everyone can see. It's their Lumsden and McCormick webinar to earn CPE credit question. So of course, everyone can answer that. And then Amanda, I'll turn it back over to you for your polling question. So I'll just read the question real quick. How many workplace investigations of an employee have you had to perform? None, 1 to 5, 5 to 10, and 10 plus. So we will give this another few seconds here, and then I will share the results for everyone. Let's see, we're close to full participation here. So.
Oh, awesome.
Yeah. Okay, I'm going to close the poll, everyone, and we will share the results.
Okay, so I see on here that the vast majority have not conducted an investigation. So welcome to our world. It's super exciting. And then we have some seasoned individuals here. How very cool. Very, very cool. Okay. So with that, for those who have not done an investigation, this is the general outline, right? We've talked about some policy considerations. Here's your general outline. You receive the complaint, okay, whether it's formal or informal. So if you receive a verbal complaint, if you receive an email complaint, if you receive one of those forms from the state of New York regarding the New York State sexual harassment complaint policy, whatever it is, you receive that complaint, that EEO complaint. We determine our jurisdiction and our scope of allegations, right? I usually do that by sitting down with the complainant and figuring out what exactly is happening from his or her perspective, okay? I determine who's my investigators, and making sure that I'm trying to avoid bias or conflict of interest, and decision makers if that's a separate individual. I review potential policies. So almost everyone has some type of EEO policy. I pull that and I have that at the ready so I can review that as I'm moving forward with this. But I also will pull codes of conduct, okay, based on what I think the allegations are. I want to pull as many policies and have them at hand for when I'm conducting my investigation to see if something else is at play. So even if it doesn't rise to the level of an EEO violation, it could be a code of conduct violation. When I'm starting off, I want to establish secure files or records, right? So we're going to be gathering some notes, we're going to be gathering documents, we're going to be writing up things. I want to make sure that whatever is on my system that not everyone in the world has access to. Sometimes I hear people say, oh, well, I just have it on the G drive. Don't do that. You need to have it password protected. You need to have it secured, right? Not everyone should be able to have access to your investigative file. Then I will prepare my list of questions for my witnesses, depending on who I've identified as having relevant information. I'm going to go ahead and conduct those witness investigations and interviews. And as I said at the beginning, you have a lot of discretion about how you want to go about doing that. Most people will start with the complainant. They will then move to the respondent and then move to non-party witnesses. But you don't have to do that. You can start with the complainant. You can talk to his or her witnesses. You can then talk to the respondent, his or her witnesses. There's a lot of different ways that you can go about doing that. You're going to ask for information in documents or photographs, depending on what the allegations are. You're going to ask that from both sides. Maybe some witnesses have some documents or photographs or texts or social media posts that are relevant. You're going to ask for copies of those and collect them. Once you've conducted all your witness interviews and collected all your documents, I really like to prepare a summary of the facts. Some employers like it to be a very, very long summary and some just very short and to the point, where, this is agreed that this happened and here's where the dispute is. The reason the summary of fact, in my view, is so important is because as employers, we have obligations to conduct these interviews. The statutes of limitations about when someone can sue for discrimination or harassment are quite long, right? And by the time someone may bring a lawsuit and then years down the road, you may be deposed as part of this. It's good to have that summary of facts for you to go back on, because if something happened 6 years ago, you may not remember exactly everything that had happened. But here you have your summary of your facts. You're going to review that summary of facts against the standard of evidence, whatever you selected. Again, most people will have preponderance of the evidence. And then the decision maker, whoever that person is, if responsibility was determined, meaning that if it was found that a respondent violated some type of policy, you're going to have to consider the potential sanctions. Again, that's the array of things that you could require, verbal warnings, written warnings. You could require additional training, executive coaching. There could be suspensions or there can be terminations. And then notifications of outcome. Who needs to know what the outcome of this investigation was, and how do you go about closing it out in your institution? All right, so with that, let's start with some real live examples that are happening in the world today. So this investigation, I've obviously changed all the names and the location. So Claire began working at Parker and Associates, which I'll refer to as Parker, in 2017 as an admin assistant. In 2020, she passes by Paul's cubicle, who's a financial planner. He's complaining about his schedule, as he didn't think he had enough new client meetings scheduled on his own schedule. So Claire bends over the computer to show Paul his schedule, and he says, "What a butt. I have not seen one like that in a while," and begins to laugh. Now, Claire is professional. She doesn't react, but redirects Paul to his schedule, answers his questions, and then she leaves. During this exchange, another admin, John, was present. Okay, so now this is what we've learned as part of our investigation. So what are we going to do? Okay, we start our investigation. Claire, however, had not immediately reported it. Okay, so she told her supervisor, Linda, something had happened, but didn't exactly tell her everything. Eventually, she does tell Linda about Paul's comments, and you'll hear this if you're in this space, this will be frequent, that some things are not immediately reported. A lot of times things are not immediately reported, but then come out later on down the road. There's no specific time limit for these for an investigation. So if something happened 6 months ago, if it happened last week, if it happened a year ago, you're still going to have an obligation to investigate. So eventually when Claire tells Linda about the comments, she also mentions that on a different occasion, he throws a stack of papers at her, right? So Linda, as the supervisor, reports the inappropriate conduct, which is great, right? We have supervisors doing exactly what she's supposed to do. And then after Human Resources becomes involved, Claire decides to file a formal complaint under the sexual harassment prevention policy, which all of you in New York have, because that's been required for years now. And then it's a specific form, because it's sexual harassment. There's a specific form that you will have adopted. So obviously we're going to do our investigation, right? We are required by law to do that. So this one's kind of a no-brainer here. But before we get into that, how many employees do you have that serve in your HR department or a similar department if you don't have a human resource department? So how many people do you have that would be able to jump in on this investigation? And so here we have none, 1, 2 to 5, or 5 plus.
I'll close it out, everyone, in just a few more seconds. All right, I still see responses coming in, so I'm gonna give it just a few more seconds to give everyone a chance. Okay, it looks like it stopped here, so we'll end the poll, and here are the results. Amanda.
Okay, all right. So the majority has 2 to 5 individuals that can assist me in this investigation. So hooray. But some do not have any. And there's a frequent amount that has none or 1. So thank you for letting me know that one. Okay. All right. So just moving along with my notes. All right, I'm going to go back one. Okay, so we're doing our investigation, whether we have people doing it internally or externally. We update the people that need to know. We determine that I'm going to be doing the investigation. We look at whether interim measures are necessary. In this particular case, in speaking with the complainant, she did not feel that she needed anything. She was offered EAP services. She was aware of where that was going to be, but did not want changing of the schedules or anything like that. Now, when you have a complainant saying, you do want to have contact with them about whether they believe that they need interim measures or services, but that is not the end all or be all. You as the employer would decide whether something is reasonable under the circumstances, right? So in these circumstances, we determined, we went with her request that she did not feel that she needed a schedule change or anything like that. And she was aware of what other supportive services the employer provided. So we went ahead and planned our investigation. Okay, so getting Claire's perspective, who does she believe the witnesses were? She's already identified John. She identified Linda, her supervisor, who she reported it to. Then we would decide when we were planning to interview those witnesses versus the respondent. And then we talked about, do you have any documents? Do you have anything else to show what you believe happened? Gathering those types of things and keeping that in our file. So in this particular instance, we decided to interview the complainant first, which made sense because we needed to know what the world of allegations were. And in those interviews, Claire said that Paul's behavior was seen as joking, and that he threw papers at her on that one occasion, but there were no other instances of inappropriate behavior. And it's important to know from the complainant's perspective, how many times things had happened, how severe things were, are there other witnesses, or were they aware of this behavior occurring with other individuals? Those are important things to know from the complainant's perspective. Now, then we interviewed the respondent, Paul. Paul doesn't recall making the statement, but doesn't believe that he would have made it. Now, I find that to be a little bit different than denying it altogether, but I'm just keeping that in the back of my mind when someone says they don't recall doing something versus no, that didn't happen, that would never have happened, I would never have done that. There were some additional assistants that were identified, and those interviews took place. They confirmed that Paul made crude comments and shared inappropriate emails, and we gathered those emails together. And then John, the individual that was specifically named by Claire, could not confirm that specific inappropriate comment, that situation that Claire initially reports, but says he wouldn't put it past Paul to make such comment based on his other behaviors. He confirmed that Paul's would sometimes cross the line and had made a previous inappropriate comment to another assistant. Now, the first half of that, where someone tells you, oh, I wouldn't put it past that person, that's just their perspective. I don't find that to be, it's not decisive of whether someone actually engaged in that. I want specifics, right? So you really will drill down with that interview. Okay, why do you feel that way? What have you witnessed before? What have you seen? What have you heard? Firsthand stuff, right? I want to hear firsthand examples about why they would say that kind of thing. All right, so what comes next, right? We've done our interviews, so we're going to review the company's training records. Why would I do that? Because in New York State, we have our sexual harassment prevention training. It's an annual requirement for all employees. So I want to check to see when everyone had been trained. I will tell you, there was another investigation I did where someone was accused of sexual harassment, and they had been trained like 3 days before they were accused of doing whatever it is that they were accused of, and actually, admitted that, yeah, I received that training, I just don't pay attention to it, right? So at least when it comes to sexual harassment, I review the training records, I review the relevant policies, you review any types of writings or photographs or things like that, if that is relevant or provided to you, and then we have to make a decision. Do you go further? Do you need to do the search for the emails or the electronic information? That is up to your discretion, right? And it's going to depend on the situation. Each case is going to be different. Now, if someone tells me I have emails and okay, I'll take a look at those. Sometimes, in this case, we were provided with some emails, probably not the full scope of emails, but it was too much of a burden because we weren't given any time frame, any keyword searches, anything like that. It was too burdensome just to go through the employer's email system and see if Paul sends any other inappropriate emails, right? The head of your IT is going to hate you if you come in and say, hey, I just want to look at everything that this person ever sent, right? You need to have at least a reasonable basis. And you need to have a limited basis to be searching for those types of records. Now, the last bullet point I have on here is reviewing prior incidents. This is something that you need to talk about in your organization and how you want to handle it. And I'm going to put Title IX issues aside, all right? So all my education people who are on here, I'm going to put you aside for a second. When determining responsibility, some employers want to look at whether the respondent was accused of or found responsible for this type of conduct in the past, okay? If it's showing a pattern, then perhaps that tips the scales about whether more likely than not it happened in the situation. Other employees say, I don't want that. I don't want this pile-on theory. I want to look at each allegation from a fresh perspective, and I want to determine, do I believe that it happened in this situation? If there's a responsibility or a finding of responsibility that yes, there is a policy violation, then I want to take a look at, has this individual been accused of this conduct in the past? is this a pattern? And if there's a pattern, I want to consider that in terms of when I'm imposing my sanction. So if I'm deciding whether to terminate or not, is this a habitual problem? Is this person not learning from training? And using that information for the sanction portion, not for the responsibility portion. I will tell you the vast majority of my clients use it, whether someone had been accused who's a habitual abuser or says bad things, they will use that for the sanction purposes, as opposed to looking at it in this, in your current investigation. All right, so what does the investigation reveal? That the inappropriate conduct is well known in the department, right? There's multiple people that can confirm witnessing and hearing these types of comments. This particular client is my outlier here. They wanted to know, had this person been accused of this in the past? Did find out that they were accused of sexual harassment in the past and at a previous employer. It was actually a public record. Apparently didn't find that before doing this investigation. Paul had underwent the sexual harassment prevention training and continued to make the comments shortly after the training. And it was more likely than not that Paul had engaged in the behavior that Claire complained of. This particular client also wanted recommendations about whether the investigator, myself, believed that future training would be helpful. And in looking at the amount of behavior that we had uncovered here, the fact that this individual had gone through multiple trainings already, I did not feel that future trainings would be useful in correcting that individual's behavior. And therefore, they did separate the relationship, the employment relationship with Paul. Now, polling question 3, does your organization have a written policy on workplace harassment? I really hope all the answers are yes, not to give you the clue of what the answer should be, but I really hope it's yes.
Thanks everyone for answering. We'll give it a few more seconds. Amanda, I just wanted to let you know we're about 8 to 12 minutes out from the close of the session. So
okay,
just so you're aware of the time frame.
Appreciate that. Thank you.
Welcome. So, okay, I'm going to end the poll, everyone, and I'll share the results.
Yay, you're all awesome. I'm so happy to hear the answers yes. That makes my heart happy. Thank you for that. That's great. Okay. So in this situation or any situation, what am I looking at when I'm thinking, do I need to term somebody? Do I need to suspend them? What am I looking at? I'm going to look at the severity, the egregiousness, or whether the conduct that they were responsible for was violent in nature, right? I'm going to look at, for sanction considerations, is this a repeat offender? How long did the conduct take place, right? Is this a one-time thing or has this been going on for years? I want to look at the effect that the conduct has on the parties, and that's the complainant and the respondent and the community at whole, right? I want to see, does this person have training on this specific topic? That's not decisive whether they were trained or not, but did they actually receive training? Did they receive our company's policies prohibiting this type of conduct? Do they have a past disciplinary history? And is it relevant to this situation, right? Because we're investigating EEO complaints. If the person has a past disciplinary history of absences, may not be relevant, but it may, under your progressive discipline policy, it's just another thing adding on that they maybe need to be headed to term. And then I also want to be consistent, right? I want to be, how has our company handled these types of issues in the past, right? I don't want to have an outlier here and there. I want to be very consistent so my employees can expect, this is how the company will handle these types of claims in every situation, okay? And so I have in here, what's your recommendation? In this particular case, I already gave you the answer that they decided to term, but you may feel that you could have handled it a different way. And we can talk about that offline. All right, investigation number 2. We're going to speed through these a little bit faster, okay? This is a medical setting. Dr. Freeman's a 55-year-old Asian ophthalmologist. She began working at the company in March of 2015, and Dr. Kevin Patterson is another physician in that group. They've been coworkers for 5 years, and they've had some previous issues with one another, but they seem okay, right? They're coworkers. They seem to be working fine together. In July of 2021, Dr. Freeman was on call, and Dr. Freeman felt uncomfortable caring for a particular patient who was experiencing some side effects after a procedure. Happened to be Dr. Patterson's patient. So Dr. Freeman gave Dr. Patterson a call asking for assistance. During that call, Dr. Patterson allegedly spoke to Dr. Freeman in a quote unquote aggressive raised tone. And that is the phrase that was conveyed to me, right? Dr. Freeman felt belittled, harassed, and bullied during the phone call. Dr. Freeman believes that she was spoken to in that manner because of her age and her race. And then she did file a formal complaint against Dr. Patterson with HR. She continued to perform her job duties, but said that she felt scared and intimidated. She had reported that she had not been spoken to in this manner before or after the phone call, and confirmed that Dr. Patterson did not refer to her age or race in this phone call. And that is a very common thing, right? We don't have a ton, we have a ton of complaints that come in that don't involve explicit harassment or discrimination, right? So they're not using those keywords that would make you think of age or race, but someone perceives that that's why that something is happening to them, and we need to take that into account. Dr. Freeman believes that Dr. Patterson had spoken to other older doctors and doctors of color in this manner in the past, and asked human resources to reach out to these physicians for confirmation, and it includes a list of former employees. And I just want to make a caveat here that Dr. Freeman is 55 years old, and that's not old, right? But that was the allegation in this complaint, that she believed that it was because of her age. All right, do you have to investigate? Yes. Simple answer, right? You're obligated under the law to investigate allegations of discrimination in these types of cases. So let's plan your investigation. What order do you want to do? How many witnesses do you want to do? Again, sometimes you're going to have a complainant or a respondent that gives you a list of people. They might give you 10 individuals that they want you to speak with. If it's a large amount of witnesses, I push back a little bit. Okay, tell me what would employee A tell me? Why are you naming them? What information did they have? Same thing with employee B, employee C, right? Because you, as the investigator, you don't want to waste your time just talking to people just to do that, right? You really want to get down and talk to people who have information. Think about what kind of roadblocks are you going to encounter. Think about your interim measures if you need anything. And for older allegations, and I'm not meaning like age-wise, but if you have a complaint that from something that happened 5 years ago, or this happened 10 years ago, pull your document retention policy, because you may need to find out whether you can even access some of that information. All right, so the interview with the complainant, she does say that there was another exchange years ago, right, 3 years ago, where Dr. Pearson allegedly said she's too old to continue working here. She's stuck in her own ways. When we spoke with the respondent denied any wrongdoing, and had a issue with Dr. Freeman because he believed that she would not take care or do her job when she was on call. That is a frequent occurrence, right? When you have a respondent who says, nope, it's not me, it's the complainant, right? They did something wrong. That is very, very common response. The complainant wanted an interview of her mentor. And so we did that, and that revealed that there was previous age and race discrimination complaints made against Dr. Freeman, but none of them were found to be substantiated. So issues always come up in investigations, right? Dr. Freeman allegedly, this email where she was referred to as old, allegedly has access to it, but refuses to turn it over. In those situations, do you need to then try to find the document yourself? In this situation, we said, I tried to get cooperation and say, hey, if you have that information, it'd be very helpful if you could provide it to me, because we did not have a date, we did not have subject matter, we couldn't do searches for it, because it's pretty old, but the complainant refused to turn it over. Same thing about, I want you to go talk to 10 individuals. I've seen people say, here's a list of 100 names. As the investigator, you have the discretion about how many individuals you're going to talk to. Talking to 100 people probably isn't a reasonable request. Talking to 10 people may not be a reasonable request, depending on the circumstances. The respondent denied the allegations in their entirety. Again, very common. Noted that it was not recorded. It occurred on one occasion. There's no witnesses to the phone call. The investigation determined that the conversation was not objectively offensive, threatening, harassing, unprofessional, nor did I mention age or race. The email from 3 years ago could not be reviewed, but the complainant indicated that she had it and she saw it. And so in this situation, what would your recommendation be? Would you find that Dr. Patterson violated your policy, your EEO policy, or something else? Did Dr. Patterson violate your code of conduct, your professionalism policy? In this case, the investigation determined that there was no policy violation. So trends. I want to get through some trends before I leave you here today for your next presentations, which are going to be amazing. When starting out these EEO investigations, some employers are going ahead and issuing a notice of investigation. Now, if you have a CBA or if you're in higher ed, you're probably already doing this. Other employers are deciding, hey, I want to advise both the complainant and the respondent in writing of what the accusations are and what's being investigated, what potential policy violations are at issue, as well as writing down, hey, we got a policy against retaliation. Some people want to send that out unless there's a law out there or your CBA or your policy requires it, and you don't have to do this, but it is a nice consideration because some people process things differently, right? Imagine if you are accused of something, an EEO violation, and you're hearing about it for the first time in a meeting with the CFO. And you may be taken aback, you may process things differently. Some people are getting it in writing ahead of time so they can collect their thoughts, collect their side of the story, and present it. That is up to you, all of you, how you want to handle it. Again, we talked about attorney and advisor requests. Just be prepared. It comes up in every investigation, every single one of them that I've seen. Somebody will ask about it, so be prepared to respond. Same thing, class of investigators. Make sure that we account for potential biases, potential conflicts of interest. Does it look appropriate? Are people rumored to be friends or dating and they're not, but they should be the investigator or the decision maker? We really want to think it through. Okay. The last bullet point I have on here is standard disclaimer to all witnesses. This is a nice trend that I'm really in favor of. Essentially, it's a handing out at the beginning of each interview a list of quote unquote disclaimers. So it would list on there, where the company's anti-retaliation policy is. So all witnesses, complainants, and the respondents know about our policy and know where to find it. And they know what to do if they believe that it's been violated. I talk about confidentiality, how we can't guarantee it, but we really encourage it. And we would appreciate if they would do that as well. You can advise them about whether you're allowing recordings, and that is a very hot topic. Okay. As the investigator, I choose to advise people that they are not to record me, keeping in mind that people probably are, unless there is a legal right to it or a CBA right to it or a policy right to it. I do not like it. And here's why, from my perspective. When I'm interviewing someone about an EEO issue, we may be talking about students. We may be talking about patient records. We may be talking about confidential trade secrets because it's coming up in the investigation. When someone is then recording you, which they're doing on their cell phone, where is that saved to? Backed up to the cloud, right? And now you have your company's private information on their personal cloud device. And I can tell you that not many people know how to delete something from the cloud. If they delete it from their phone, it does not delete it from the cloud. So I really, really do not like when people record these conversations, especially when you get into these very sensitive and confidential conversations. So I really discourage it. I recognize that it probably still happens and that people are still recording me, but I usually will advise them at the beginning that they are not to do that. Confidentiality, reviewing that with the witnesses. You consider what you will do if a party or witness shares information after being asked not to. And what I mean by that is, a complainant or a respondent may talk to his or her witnesses ahead of time, and that could influence their statements to you. So when I'm talking to third parties, I ask, had anyone spoken with you about this before? Okay, what did he or she tell you? What did, and really try to drill down to see if the witness has become biased or been provided with altered testimony or altered statements for me. Time frame considerations. I want to conduct a fair, impartial investigation. That's what our employees deserve. I want to do it in a timely manner, but sometimes life happens, right? People are out, COVID strikes. We all know that. People are on vacation. Something happens where these things get delayed. I don't want to agree to or guarantee a specific time frame unless I'm legally required to or I'm required to by your policy. Lastly, we have on here amnesty policy. This the greatest example I have is for those educators out there who have the New York State policy for sexual harassment and sexual abuse. Some people will say, hey, I'm afraid to come forward because if I tell you what happened or if I tell you what I witnessed, I'm also going to be disclosing that I violated some of the employer's policy. And this, the state example is for students who come forward with complaints of sexual harassment, stalking, those types of issues. If they were found to have been doing drugs or alcohol, they have a quote unquote amnesty policy. They can't be brought up on conduct charges for that. So some private employers are also taking that route, that we really want to encourage fair and impartial investigations. We want fulsome statements, and people who are afraid that they're going to blow themselves in for a policy violation may not be as forthcoming or as truthful as we want them to be. It's a consideration for you guys to think about. I'm not telling you one way or another whether you have to do it or not. It's just something that I've seen a lot of employers talk about lately. So polling question 4, does your organization have a policy on recording in the workplace? Super hot topic, right? Very, very hot topic. People are recording everything all the time. How is your organization handling it? Do you have a policy on it?
I just want to draw everyone's attention to the fact, I know we're running a few minutes late, but we will start the next session a few minutes later as well. So you can hang on. Amanda only has a few more slides and then we'll wrap up. And again, we'll start the second session a few minutes late. I'm going to give this just a few more seconds here. We're just about 87% participated here. So I think here we go. A few more. Everyone's listening, which is great. Okay, I'm going to end this poll here and I'll share the results. Thanks, everyone.
Okay, all right. So the majority of you do not. All right, that is a consideration that really we need to be talking about ensuring people that feel that they have rights and that they're protected, at the same time protecting our organizations and our investigations. Okay, so with that, you're going to be considering weighing your evidence, right? You're going to be looking at who presented, how they presented, their versions of events, whether it was corroborated or not, and the potential motives of everyone, because everyone has the reason to tell the truth. Everyone has a reason to lie. I want you guys to be comparing the witness statements to the documents, considering relationships to one another, and looking at inconsistencies. Are they reasonable inconsistencies? Because time has gone on and we all can't just remember everything that happened, or are there greater inconsistency than just time in itself? Communication. So under our New York State sexual harassment prevention policies, the complainant and the respondent are notified of the outcome of sexual harassment investigations, are you going to do the same for your other EEO categories? Are you going to go ahead and notify both sides? Are you going to treat them just like you do your sexual harassment prevention policy violations? It's a consideration. In
And
addition,
we have a quick question.
Yeah.
I'll interrupt. The question is, I was under the impression that it was legal in New York State to record a conversation without disclosing that you were recording. Something to be aware of when you are speaking to an employee, if true.
Yeah, so that's a really good point. So what you're referring to is that New York State is a one-party consent state, meaning that as long as one person consents, and it's usually the person recording, that person is not violating a criminal statute by doing that. Okay. But just not violating a criminal statute is not necessarily the same as whether you're allowed to do it at work. Right. And so that's where I use the difference. And I'd also be very cautious, especially when you have a lot of people working remotely or people traveling and working in different states. Different states have different regulations about recording. So for example, California is a two-party state. Okay. If you have two people on the conversation, both have to consent to the recording. So if you have an employee who's recording another employee who happens to be in a different state, you're going to need to know what those regulations are too. Illinois has some pretty strict criminal statutes when it comes to surreptitious recording. So we have to be very conscientious that it may not just be New York State, and just because it's quote unquote not illegal doesn't mean that it's allowable. And then, so I had lastly on here, additional policy violations. I'm seeing a lot of people that as you're doing your investigation, originally you notified the respondent that he or she is accused of doing X. As you continue on in your investigation, you find out there's more stuff, whether you're going to amend, and then you give that respondent an opportunity to address those amended allegations. And I think that that's fair in terms of due process. If you're going to expand your investigation greater than it originally was, that you should be notifying the respondent and giving him or her or they an opportunity to respond appropriately. So with that, I really appreciate you having me here today. I'd be happy to chat with anybody offline. I love talking about investigations. We can talk about stories. I don't name anybody. It is just, I'd be happy to talk to anyone. If you're conducting your own internal investigation and you just have a quick question, hey, what would you do in this situation? Just give me a call. We can chat about it, no problem.
Great. Thanks so much, Amanda. We appreciate this, and it definitely sounded super interesting to get all the nitty gritty and kind of the gossip of all these stories and the behind the scenes. So again, Amanda's offering. If you have any questions, feel free to call her. Again, her contact information is listed in the bios, which are on our website. And I did share a link to her website page on the Phillips Lytle website. So you can copy and paste that and reach out to her. We'll also share all the contact information in a follow-up email at the end of the conference for everyone who spoke. So again, thanks to everyone for attending. The next session isn't starting till 10:05, so you have a few minutes to take a break and log into the next one. So we'll see everyone on the next one. And again, Amanda, thank you so much.
Thank you, Maria. Thank you, everyone.
Great. Take care, everyone.